A couple weeks ago, in a case called Baird versus Bonta, the United States Court of Appeals for the Ninth Circuit, based in California, issued a major ruling dealing with open carrying of firearms. But it's not huge for the reason that's been reported on. It's extra huge for the Second Amendment in a way that hasn't been talked about nearly enough, if at all. I want to explain to you why this Ninth Circuit ruling is going to be a very big deal for gun owners in California very soon. You'll see why when we get back and talk about it. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the A to Z guide about how the anti-gunners intend to take away our rights if we let them do it, which I know we won't. All right, folks, so a couple weeks ago, you probably read about this case out of the Ninth Circuit Court of Appeals in California called Mark Baird and Richard Gallardo versus Bonta. This is a challenge, a constitutional challenge under the Second Amendment to California's criminal law dealing with the unlicensed open carry of handguns. There was a lawsuit brought claiming that this violated the Second Amendment. The federal trial court, which is the United States District Court, denied the injunction and basically did a backdoor tiers of scrutiny balancing of the interest, good and bad on guns, and has simply said that because the government has an interest in stopping gun violence, guess what? The Second Amendment doesn't matter that much, and the motion for a preliminary injunction on behalf of the plaintiff was denied. So the plaintiff took this immediate appeal, to the Court of Appeals for the Ninth Circuit. I'm happy to report, and this is the headline news, and then I'm going to get into the geeky news, which is much more important than the headlines. The headline news is the Ninth Circuit Court of Appeals reversed the district court and said that the district court failed to do the proper analysis of a preliminary injunction for Second Amendment cases and reversed the denial of the motion for a preliminary injunction and sent the case back to the district court for further findings and for a redo of the motion for a preliminary injunction and told them to redo it. So that is big news in and of itself. And the headline was in all the newspapers that the Ninth Circuit Court of Appeals has reversed a district court denial of motion for a preliminary injunction and sent it back for further information, findings, and conclusions and analysis. That was the headline. But let me tell you why this case is really important and why it's going to have a ripple effect on all the cases in California, all the gun control challenges in California in federal court, and in all the constitutional claim cases out of the Ninth Circuit in its entirety. It's because of the standard, not of the Second Amendment, but the standard it set forth for preliminary injunctions. Specifically, to get an injunction, 4 elements have to be satisfied. The first is that the plaintiff, in our situation, in our world, the Second Amendment plaintiffs challenging a gun control law, the plaintiff has to be likely to succeed on the merits, likelihood of success on the merits, meaning that the claim against the gun control law is likely to succeed. That's the first element. The second one is that there's irreparable harm, which inevitably there is. If you're likely to have your constitutional rights violated, then by definition that constitutes irreparable harm under longstanding Supreme Court precedent. So if you win on likelihood of success on the merits, you basically also win on irreparable harm. So the 2 other elements of the 4 elements for a preliminary injunction, in addition to likelihood of success on the merits, plus irreparable harm to the plaintiff, if the injunction is not granted or given, is a balance of the equities, kind of the good and the bad, as well as the public interest. Well, the Supreme Court and other courts have said repeatedly that governments have no interest at all to be balanced if they're violating a constitutional right of an American. So once a plaintiff arguing that his Second Amendment rights have been violated, once the plaintiff shows he's likely to succeed on the merits, he wins really the injunction for all intents and purposes. Because once you make that conclusion, the court makes that conclusion, he is viewed to have suffered or will suffer irreparable harm without an injunction. The balance of the equities only can weigh in his favor because the government has no interest at all in enforcing an unconstitutional law, nor does the public have an interest in having an unconstitutional law enforced. So do you see, given those four factors for a preliminary injunction, at the end of the day, the whole ball of wax is whether or not a court concludes that a Second Amendment plaintiff is likely to succeed on the merits, and that it is likely the case that the modern gun control law being challenged is unconstitutional under the Second Amendment and its jurisprudence, including Heller and Bruin and Catano. All right, so why is all of this important? And why is this Baird versus Bonta case important? You see, what happened is, and I've been warning about this before, and in some of my speeches and lectures, even to the Federalist Society, I think I've talked about this. What we have to be careful of in the Second Amendment community, and what judges have to be careful of, is allowing tiers of scrutiny or interest balancing of the good and the bad of guns to sneak in through the back door in some ways. Because the Supreme Court in Nysurpa versus Bruin made very clear, and they also did it in Heller as well, but they made it extra clear in Bruin, that interest balancing, tiers of scrutiny, strict scrutiny, intermediate scrutiny, all these kinds of good and bad, you weigh the government interest on the one hand against the interest of the gun owner on the other hand, and you balance it all out. The Supreme Court says this is totally verboten. This is not allowed. It's prohibited. There's no excuse for violating the constitutional right. You can't balance it away. And that's why I've always said on this channel, no matter who says otherwise, even if you think they're good on guns, do not believe them. If anyone tries to say tiers of scrutiny is a good idea, or balancing the interest or interest balancing involving the Second Amendment and a right to keep and bear arms, you tell them, go pound sand. They're 100% wrong, and I don't care who tells you that. That is wrong. You don't want that. And the good news is that the Ninth Circuit, in setting the guidelines going forward for all Second Amendment cases in the Ninth Circuit, which is all the Hawaii cases, by the way, all the Arizona, all the Washington State cases, all the California cases. Those states sound familiar to you? A lot of them are anti-gunner states. Yes, indeed. The standard is that you laser focus on likelihood of success on the merits. That is where the whole fight is to take place. That is what the Ninth Circuit said. And they specifically said, going forward in Second Amendment cases, that must be done first. Likelihood of success on the merits. Let me read to you what the Ninth Circuit has said. Remember, this is the law that is going to be applied to among not just Ninth Circuit judges, but lower court judges in the district courts like Judge Benitez. This is the law that's going to be applied, and it's very good for us on preliminary injunction matters. The Ninth Circuit wrote in the Baird case, as noted, the likelihood of success on the merits is a particularly important consideration in the preliminary injunction analysis of a constitutional claim, because a finding that the plaintiff is likely to succeed on the merits of such a claim sharply tilts in the plaintiff's favor both the irreparable harm factor and the merged public interest and balance of harms factors. Consequently, a plaintiff who can show that a statute likely violates the Constitution will also show that both the public interest and the balance of equities favor a preliminary injunction. The court goes on to say, and this is huge, because remember, this is the law that's going to be applied in future Second Amendment cases from this moment forward. So although I support open carry of firearms in California, and that is the headline issue, that the open carrying of firearms is being litigated right now in California, and I wish them Godspeed. But the real exciting news is this geeky inside baseball change of the standard, or emphasis on the standard, on the likelihood of success on the merits, because it does two things. One is it forces the courts to do the Nysurpa versus Bruin methodology, which is very good for us because it shifts the burden to the government to come forth with historical analogs from 1791, which is very difficult to do because in 1791 there are very few gun control related laws. And the other huge thing that helps us out in the Second Amendment community is it really shuts down the opportunity for lower courts to abuse and sneak in the back way tiers of scrutiny or interest balancing by claiming, oh, well, we're going to start We're not going to look at likelihood of success on the merits first. We're going to go the back door, and we're going to check out the balance of the equities and public interest and stuff like that first to see, no. The Ninth Circuit says, no. You start with likelihood of success on the merits. You don't talk about any of these other issues until you do that first. That's great news for us. So the court again says, notwithstanding the settled interplay between the factors, the district court here declined to undertake any inquiry into the plaintiff's likelihood of success on the merits of their Second Amendment challenge to these California laws. Instead, the district court conducted only a merged analysis of the third and fourth factors of the preliminary injunction standard and proceeded to deny the injunction after concluding that because the public interest and balance of harms disfavored the issuance of a preliminary injunction, it was not necessary to assess applicants, meaning the plaintiffs, likelihood of success on the merit. This was an error. In a case presenting a constitutional claim, it is always necessary for a district court to determine whether the plaintiff is likely to succeed on the merits because of the influence such a finding has on the other preliminary injunction standards and factors. Put otherwise, a federal district trial court that skips over analyzing the first factor where the plaintiff alleges a constitutional violation cannot properly evaluate the other factors. Then the Ninth Circuit says, here in this case dealing with the open carrying of firearms in California and the constitutional challenge under the Second Amendment to California's ban on the open carrying of firearms, and you go to prison if you open carry without a license, the Ninth Circuit says, quote, by denying the plaintiff's motion to enjoin California's general open carry ban based solely on its conclusion that the public interest weighed against plaintiffs, the federal trial court, or the district court, thus employed an incorrect legal standard for the issuance of a preliminary injunction and therefore abused its discretion. Period, full stop, bang. Bang. That is a geeky detail that you learn here on the Four Boxes Diner. But this alteration of the standard for a preliminary injunction in the Ninth Circuit dealing with constitutional claims, including claims under the Second Amendment's right to keep arms, is the huge deal. This ripple effect is not just going to affect the Baird case involving the open carrying of firearms and the fact that it's been banned in California and it's a crime if you do it. This change of the standard is going to have a ripple effect in all cases in the Ninth Circuit, and not just at the Court of Appeals level, but at the federal trial court level in all these critical anti-gun states of Hawaii, California, Washington, and so on. So again, this Baird versus Bonta case we have to watch very carefully, not just because of the open carry issue and the carrying of guns issue and outside the home for self-defense in public and so on, but also because of this change in the standard or emphasis in the standard in Second Amendment claims on dealing with preliminary injunctions, which of course happens all the time. Preliminary injunctions occur all the time in Second Amendment litigation. It is a big deal. And if you win the preliminary injunction, that usually tells you and tells everyone that you're likely going to win the permanent injunction because you're on the right path to victory. So, all right, folks, I hope you did not find this too geeky here today at the Four Boxes Diner, but I hope you learned something. And again, if you haven't subscribed on at Twitter, at Four Boxes Diner, please do so. And don't forget to subscribe and like this video. It makes a big difference in distributing my videos out there to the Second Amendment community. So if you haven't subscribed, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.